Well, hello there, you amazing, amazing, beautiful, wonderful people. I hope you are all well on this thirsty Thursday. It is I literally, I don't trust myself. Whenever I say days, I don't trust myself. I don't know why, because I'm so good at the days. Anyway, did you watch the court hearing in the Idaho 4 yesterday? You're looking absolutely amazing, I must add. Yeah, what a debacle it was. But anyway, look, if you didn't see it, now later on today, I will release a trimmed down version of yesterday's live. For those who just want to get to the point, just get to the point and look at the hair, and you'll get to do that. All right, so keep your eyes peeled. If you're not subscribed, smash like and all that jazz, the bell, the notification bell, do all that so you won't miss it. But in this video, there has, of course, been a response to yesterday's hearing in the court documentation, and we're going to be going over that right now because it was a little bit of a railroad of sorts. So we go over it together? Let's have a look. It's quite a doc, but it needed to be said. Was Hitler wrong? So this is what we've got here. We have got a defendant's reply to the state's opposition to defendant's motion to continue, and we know that this was anticipated. The outcome of that hearing had been anticipated, and Taylor knew it was coming, and this doc was filed just shortly after in response to said hearing. So let's have a look. It says, comes now Bryan C. Kohberger through his attorneys of record and hereby submits his reply to the state's opposition to defendant's motion to continue filed with the court on June 5th, 2025. The state's objection to Mr. Kohberger's motion invites reversible error. Prosecutors have an ethical and legal obligation to seek justice over convictions. It says Idaho Rules of Professional Conduct, Rule 3.8, Special Duties of a Prosecutor. When defense counsel requires a continuance to complete the constitutionally required mitigation investigation, the state has no legitimate interest in objecting, for any conviction and or death sentence obtained under such circumstances would rest on a constitutionally defective foundation. As such, courts reviewing death sentences have recognized that when attorney error amounts to constitutionally ineffective assistance of counsel, that error is imputed to the state. Coleman versus Thompson. For when a state obtains a conviction against a defendant who was denied the effective assistance of counsel, it is the state that unconstitutionally deprives the defendant of his liberty. And then it quotes some other cases here. And we did talk about this yesterday. We did say, this is when Ann Taylor has gone on record and said, I'm not ready. I'm not ready. She works for the state. She works for the fucking state. It's not Bryan Kohberger's fault if Ann Taylor isn't ready. And if Ann Taylor isn't ready because inactivity or activity of the state, which is inclusive of law enforcement and prosecution with respect of leaks of information that lead on to a Dateline NBC documentary, then it's not his fault. But we'll continue. Look, it gets worse. The state suggests that counsel's prior compliance with a court scheduling order somehow weighs against the present request for a continuance, but defense counsel's adherence to deadline demonstrates diligence, not finality. Compliance was a good faith effort to meet the court's expectations, not a concession that defense investigation is complete. The defense has now identified information and developments that make clear additional time is necessary to meet the minimum standards of effective assistance of counsel under Strickland versus Washington, and to fulfill the capital defense duties articulated in Wiggins versus Smith and other Supreme Court cases. The fact that prior deadlines were met does not somehow negate the need for a continuance where the timeline is insufficient to complete the investigation and presentation of a constitutionally adequate penalty phase defense. Defense counsel has provided a detailed showing of good cause and necessity, including specific investigative avenues that case law explicitly establishes as constitutionally required in a capital case, through the ex parte pleading and an accompanying affidavit from the mitigation specialist. The purpose of ex parte pleading was to provide the court with this critical context without revealing privileged work product and trial strategy to the prosecution. The court is therefore apprised of the scope and necessity of the additional investigation, and the record does not support the state's assertion that all relevant ground has already been ploughed. Mr. Kohberger's case has been pending for less than 2.5 years. That is a short duration compared to other capital cases, and they do go on to list a load of cases and look at the time frames of them as well. So, thus proving that this is moving, even though it feels a long time, and we're all quite impatient beings on the grander scheme of things. With the nature of this case, it's in quite its infant stages. The state's suggestion that defendant is seeking a perpetual continuance mischaracterizes the request. The defense is not seeking an indefinite delay. It is seeking a reasonable and necessary adjustment of the trial schedule to allow constitutionally required mitigation investigation to be completed. The absence of a proposed new trial date simply reflects that the next appropriate step would be for the court to vacate the current trial date and then enter a revised scheduling order based on input from all parties, as is customary. It is both common and appropriate in capital cases for trial schedules to be revised as new facts emerge or as the defence becomes aware that essential tasks cannot be completed in the time originally allotted. The defence identifies specific areas of investigation that are outstanding and has submitted those to the court ex parte for review. The precise amount of time needed will depend in part on the results of those ongoing efforts. The state's assertion that over 2 years should be presumed sufficient time ignores the law and the practical realities of capital litigation and the high-profile nature of this case. The Sixth Amendment right to effective assistance of counsel does not impose a rigid calendar requirement. It guarantees a meaningful opportunity for counsel to prepare and investigate under the facts and complexities of the individual case. Denying the continuance based solely on the passage of time without considering the specific barriers, scope of investigation, and recent developments would be an abuse of discretion. However, even gagging with the state's flawed argument However, gagging, Freudian slip, with the state's flawed argument, 2 years and 3 months between indictment and trial is less time than in many run-of-the-mill capital cases that are not high profile. The Federal Death Penalty Resource Council tracks federal capital counsel cases and published a resource in 2021 tracking the amount of time it took for cases brought to trial between 2010 and 2020 prior to the pandemic, which slowed everything down. The average time between indictment and the beginning of trial was 1,299 days, or 3.55 years. See the declaration of Ben Cohen regarding time period between indictment and trial in federal death penalty cases between 2010 and 2020, attached as Exhibit A. And recent high-profile cases have taken longer to get to trial. For example, defendant Nicholas Cruz in Florida was pre-trial for more than 4 years. This is even true even though he pled guilty, leaving the penalty decision of life without parole or death penalty as the sole issue to be decided. This capital case is extraordinary both in complexity and media attention. Mr. Kohberger's case is not an ordinary capital case. The defence has had to navigate extraordinary barriers, including reluctant or traumatised lay witnesses, difficulty retaining qualified experts because it is a highly publicised and controversial case, ongoing prejudicial media coverage, including violations of court orders that have required legal and strategic attention, and logistical delays in a complex mitigation investigation across multiple institutions and jurisdictions. Even though 3.5 years represents an average pre-trial timeline in capital litigation, the average does not account for added complexity, resistance, and logistical challenges inherent in this case. At the current trial setting, Mr. Kohberger's case will be less than 2 years and 3 months from indictment. Rushing this case to trial on the schedule that is both shorter than average capital cases and without flexibility to account for the added complexity will compromise the fundamental rights guaranteed to Mr. Kohberger under the 6th, 8th, and 14th Amendments and make any resultant conviction and or death sentence vulnerable to reversal, which I absolutely 100% feel that is exactly what will happen if this goes to trial. Absolutely, without a doubt. The recent Dateline episode of Media Leaks are uniquely prejudicial and distinct from ordinary media coverage. The state's argument that the Dateline episode does not require a continuance and that, in fact, proceeding to trial as scheduled may actually avoid any negative consequences from future publicity completely misses the point. The defense is not asking for a continuance based on the ordinary publicity that attends high-profile criminal proceedings, such as coverage of court dates and public filings. This is something wholly different, a highly dramatized TV special complete with ominous music and narrations, first-person testimonials, faux experts, and non-public information that was leaked in violation of the court's non-dissemination order. Stick that in your pipe and smoke it. It was a choreographed narrative broadcast to millions of viewers and advertised to millions more. It aired nationally and was promoted heavily across commercial breaks, streaming platforms, and social media, maximizing its visibility and impact. It was designed to provoke strong emotional reactions, which is exactly the influence that taints jury pools and risks depriving Mr. Kohberger of a fair trial. Worse still, a book that claims to contain the most comprehensive narrative of the investigation and evidence to date is set to be published on July 14, 2025. It promises information based on interviews with local law enforcement. Its release will almost certainly trigger another wave of media coverage just 2 weeks before jury selection is set to begin, and if the publisher's claims are accurate, that coverage will likely include non-public information presented not under oath or subject to cross-examination, but packaged in a narrative designed to provoke public interest and sell books. If the book contains new leaks, a further investigation into the source of those disclosures will be necessary, and that's the James Patterson, the Idaho 4, an American Tragedy book, which is advertised on Amazon. The book is not the end of what is to come as the trial begins, as currently scheduled. Amazon Prime Video is releasing a docuseries on July 11th, 2025, called One Night in Idaho, The College Murders. It is a 4-part series. It promises to hold in a captivating, tense, and emotionally wrenching detail by people who are likely to be witnesses in trial. The families of Ethan Chape and Madison Mogan are extensively interviewed for the series, according to press materials and the trailer. Further, James Patterson, author of the aforementioned book, is noted as one of the directors and producers of the docuseries. These publications, dispersed at the time the trial begins, will capture untold attention and will be media fodder, especially as witnesses in this capital trial take the stand. Thus, the appropriate remedy is to investigate the sources of the violations, and impose accountability, not to force this case to trial in the shadow of tainted public discourse. Time will both allow this court to reassert control over the fairness of the proceedings by imposing accountability, which will communicate the seriousness of the violation and the importance of a fair process, and will allow the effects of this particularized and inflammatory coverage to subside. Because this is not an objection to the ordinary media coverage of this case, the prosecution's assertion that proceeding now will avoid further prejudice only holds true if one accepts that leaks and violations of court orders will continue. That is not a valid presumption on which to base denial of a continuance. It is a reason for investigation and enforcement. It would be patently unfair for the state's case to be bolstered through the prejudicial coverage that resulted from the state's actors violating the court's non-dissemination order, and then to use that unlawful conduct as a justification for rushing to trial before the defense can learn where the leaks originated and before the defense is ready. She's not wrong. She is not wrong. And if anybody thinks that that is wrong, then it's no longer about what is right for you. It is just about seeing Bryan Kohberger burn. Additionally, for investigation, the leaks must occur prior to any trial because it now constitutes a known source of Brady material. Interviews with Dateline producers by Idaho news outlets indicate that it was likely multiple sources who leaked sealed information to the media. If any of these unlawful leaks originated from witnesses the state intends to call or from others involved in the investigation, the information is relevant to impeaching their credibility. If the leaks were ongoing and collective, it would tend to show the willingness of investigators to violate court orders, bias against the defendant, or even collusion, which is not only relevant to the credibility, but may be exculpatory in nature. And if the investigation reveals that the state agents had information about the leaks but failed to disclose it, the omission itself would constitute a Brady violation requiring consideration of remedies. Of course, the identity, motives, and actions of those who violated the court's order are key to the jury's determination of the facts, because the case hinges on whether the police investigation was conducted in a reliable manner. I lost my place there. Where are we? Conduct in a reliable manner, or whether it zoomed in on the defendant at the expense of all other suspects. In short, the prejudice from the Dateline episode requires a continuance both because of the resultant prejudice that is separate and apart from ordinary media coverage, and because trial cannot go forward without a thorough investigation into which persons leaked case information and numerous sealed photographs and videos to the media. Current jury selection process does not allow enough time to select a fair and impartial jury under the circumstances. The state asserts that the court's carefully crafted jury selection process has every chance to produce an impartial jury. To the contrary, the court has only scheduled 2 weeks for voir dire, which is wholly insufficient to conduct the necessary individual voir dire on the vast media coverage as well as death penalty views. Given the popularity of Dateline and the intense public interest in the case, it is not speculative to assume that a significant portion of the jury pool has been exposed to the recent show, either directly or through previews, headlines, or word of mouth. Any discussion of the extremely prejudicial narrative outside of individual voir dire is likely to taint the entire group. It is not the defence's position that no fair jury can ever be impaneled in this case, only that under the current schedule and in light of this development, the safeguards in place are not sufficient to ensure that process. Relying on voir dire alone, particularly in such a compressed format, is not adequate to protect Mr. Kohberger's right to an impartial jury under the 6th and 14th Amendments. Mr. Kohberger must also be able to conduct expansive voir dire and not be limited to short timeframes and large panels. Constitutionally appropriate voir dire in a capital case takes time. Mr. Kohberger must have the necessary time to determine a potential juror's ability to sit on this highly publicized capital case. The ABA guidelines define the prevailing professional norms for effective assistance and are statutory adopted in Idaho. The state argues that the court need not consider the ABA guidelines for the appointment and performance of defense counsel in death penalty cases and cites as authority State versus Porter, and Hall versus State. First, the state mischaracterizes Hall versus State, which does not address the ABA guidelines at all. The only time the ABA guidelines are mentioned are in a parenthetical explaining state versus Porter, the court's narrow holding in Hall, which is that Idaho law applies standard discovery practices in capital cases in a post-conviction posture, has no bearing on this case. The state's other cited case, State versus Porter, a 1997 case which the Idaho Supreme Court declined to adopt the ABA guidelines. This case predates later U.S. Supreme Court case law that specifically cites the ABA guidelines as evidence that courts rely on when determining whether trial counsel's performance met the constitutional threshold. Thus, the fact that the guidelines were not adopted as binding law in Porter does not diminish their authority as a reflection of the professional consensus about prevailing professional norms. The holding isn't unusual. The guidelines have not been adopted as binding law by any state Supreme Court. However, the Idaho Public Defender Statutes adopted in 2023 requires the state public defender to implement the ABA guidelines for defending attorneys delivering indigent offence CIC 196005. The guidelines, therefore, have even more force in Idaho than elsewhere, though in any jurisdiction they are the most authoritative source of counsel's professional duties in a capital case. Post-conviction courts will use them as a highly persuasive authority when evaluating whether counsel conducted an adequate mitigation investigation, whether appropriate experts were consulted, and whether the defense team performed consistent with capital defense norms. The state also relies on a quote from Cullen versus Pinholster that omits critical context. Beyond the general requirement of reasonableness, specific guidelines are not appropriate. The next sentence states that this is because no particular set of detailed rules for counsel's conduct can satisfactorily take account of the variety of circumstances faced by the defense counsel or the range of legitimate decisions. It goes on to reassert counsel's duty to conduct the reasonable investigations under the circumstances and the importance of looking to standards of professional practice at the time of trial. Guidelines will not be read to constitute per se violations of the Sixth Amendment, does nothing to advance the state's argument. It does not undermine the relevance of ABA guidelines in assessing prevailing professional norms and the reasonableness of counsel's investigation and performance. The state does not and cannot cite any authority holding otherwise. A continuance is necessary to enforce Mr. Kohberger's state and federal constitutional rights, and these cannot be overridden by the victim's rights provision. The state asserts that the court should deny a continuance based on the victim's constitutional right to a timely disposition, Article 122 of the Idaho Constitution, but that provision does not and cannot override the defendant's fundamental constitutional rights, including the rights to a fair trial and the effective assistance of counsel under the 6th and 14th Amendments to the U.S. Constitution and Article 1 to 13 of Idaho Constitution. Mr. Kohberger's fundamental constitutional rights are not in tension with the interests of victims. They are essential to ensuring that any outcome is fair and reliable. A constitutionally sound process which includes adequate time to develop for cause challenges during voir dire in a capital case is the only one that can serve the interests of all parties, including the victims and the public. Timeliness is also context dependent. The state voluntarily elected to seek the death penalty, knowing full well that doing so would trigger more demanding investigative and procedural obligations, including a comprehensive mitigation investigation and heightened constitutional standard. That decision necessarily guaranteed a longer, more complex pre-trial process and a guarantee that the victims' families would have to wait longer for resolution. These are not unforeseen consequences. They are inherent in the state's pursuit of the most severe punishment available, which, again, she's absolutely spot on. I wonder whether she's Angling here. This does make me wonder whether she's Angling. Now, could the state come back and take the death penalty off the table and accept that as an effect of the recent leaks? And could they then say, well, if we take the death penalty off the table, will you agree to retain the incoming trial date. Now, I still don't think that Anne should ever do that. I don't know whether there is an ability to do that either, because ultimately she's just said that she's not ready. They're just not ready, are they? If the state believes that the wait is too long, or that the required procedural rigor is incompatible with its preferred timeline, it has the ability to withdraw its note of intent. There we go. It literally in the next sentence. Its intention to seek death. A non-capital trial could occur this summer without inviting constitutional error, reversal, and a significantly longer process. See, I don't know. I feel uncomfortable with this section now, as this almost says, "Oh, right, so you're angling to get the death penalty off the table, and it's not so much that you're not ready, because you're either ready or you're not." So yeah, this bit here, I wondered whether she was going with that. It seemed like she was angling there, and then with that next paragraph, it almost sort of concluded that that's what they're doing. But anyway, a continuance is necessary if the case remains capital. Notwithstanding the state's superficial chart, the chart merely lists broad topic areas and claims that the defense has some related records. That says nothing about whether the defense has completed important specific investigative avenues or is in a position to present that information coherently and effectively at trial. The repetitive assertions that family members can testify about this topic at trial and any missing records have been available to defendant and can be obtained prior to the penalty phase. Likewise, hold no weight. This ignores the complexity of securing reliable testimony that has been investigated and corroborated, and real-world barriers to obtaining records. A state surface-level examination of significant barriers and proposed method of mitigation presentation by the defence is exactly what would result in reversal, as explained in the motion to continue. Constitutionally effective mitigation, investigation and presentation requires a process that advances as new details emerge, contextualization and trust building with sources none of which the state accounts for. And the conclusion is Mr. Kohberger's motion to continue is grounded in the need for a full investigation for all mitigating factors reasonably present in his background, as well as his right to present such mitigating factors in his capital case, so that the jury has the information necessary to make an individualized sentence and determination. Further, the motion is grounded in Mr. Kohberger's right to a fair and impartial jury. As such, his motion to continue must be granted to protect his rights under the state and United States constitutions. There we go. And I'm not going to read through this. I'll just run it up the screen. So if you want to read this and pause it, you can. This is just looking at other cases and how long they have indeed taken. There's a few pages of it here. Just for those who are interested. Average days, number of cases, average days, death, life total. Got some statistics there. And there's a table with all of them literally there, and we can move that across. Again, this is just for those people who would like to pause that on the screen and have a look at those. And that is the doc. That is the doc. Let me know down below what you think. Like I say, I felt a little bit uncomfortable in that because ultimately you're either ready or you're not. So what she's saying is take the death penalty off the table and we're happy to proceed. Obviously that does change some of the things that she would have to do, but ultimately would it be right to say, well, we'll accept this book coming up right before trial then, we'll accept this 4-part docuseries, and we don't think that will then affect the trial if this is a non-death penalty case. See, that's where things get a little bit off for me. But let me know down below what you think, and I'll catch you all in the next one.